Welcome to the Harmony Group series on the legal implications arising from the COVID-19 pandemic. My name is David Pick. I'm a partner at the law firm Brownlee LLP in Calgary, Alberta, Canada. Brownlee is a member of the Canadian Litigation Council, which is Harmony's sister group in Canada. Canadian Litigation Council and the Harmony Group are invitation-only networks of vetted law firms which specialize in defense services. Our two networks are affiliated with like-minded firms around the world. Today, I'm going to speak to you about business interruption, or BI, insurance in Canada. This 10-minute presentation will focus on three areas. First, the availability of coverage for BI losses and some possible guiding cases. Second, potential exclusions to such coverages and how those exclusions may be interpreted. And third, what the future might hold for BI losses arising out of the COVID-19 pandemic. We all know by now that the COVID pandemic has caused massive economic harm to businesses around the world. In Canada, reports say that 77% of small businesses have reduced operations or closed due to the pandemic. Many of these businesses are now looking to their insurance policies to try to offset financial losses due to reductions in their operations or their complete closure. BI insurance is common in most CGL policies. BI policies cover a loss of profit, or may even cover expenses such as rent, utilities, payroll, or even taxes incurred during a period of reduced operations or when the doors are closed. These damages must be the result of an insured peril, and coverage can be for a limited period, either until the business reopens or until the businesses reach a level of revenue that existed prior to the loss. There are normally two types of policies which provide for BI coverage. They can be either in a named peril policy or in all-risk insurance. Named peril policies provide coverage for a list of specific risks, while all-risk policies, as the name implies, encompass any risks, subject to a list of exclusions. Either of these policies will usually require that the interruption to the business be due to direct physical loss of or damage to the insured's property. Since most BI policies require proof of physical damage to property, the courts will need to interpret what constitutes the physical damage itself. And there are two competing theories here. First, whether physical damage is limited to actual physical damage to the insured's property, or alternatively, if there is no direct harm to that property, whether there has been any impairment due to the ability to use that property. Earlier this year, the Ontario Superior Court of Justice, in the case of MDS Inc. versus Factory Mutual, determined that a government-ordered shutdown of a nuclear reactor due to radiation from a leak of radioactive water constituted physical damage despite the fact that the reactor itself was undamaged. The reactor produced radioisotopes, which the insured purchased for further sale. The insured had an all-risk policy, which covered losses directly resulting from physical loss or damage. The court in that case found that all risk policies should be interpreted to provide for broad coverage, and that it was not necessary for the insured to show direct physical damage before BI coverage could be enforced. Another relevant case comes from Prince Edward Island. In D.P. Murphy versus Laurentian Casualty, a civil authority prevented access to the insured's business due to gasoline fumes that came from an adjacent building. The court found that the BI coverage was triggered, subject to any exclusions, which I'll talk about later, even though there was no damage to the insured's premises. We might point out that MDS and the D.P. Murphy cases may have limited applicability when it comes to determining what happens in the COVID crisis. Courts may differentiate losses due to COVID as different from the radiation in MDS or the gasoline fumes in D.P. Murphy, both of which were seen as physical threats to the building's structure. It is doubtful that COVID would be seen as such a physical threat. In addition, the order in MDS made business operations impossible compared to government orders in the COVID-19 pandemic, which in many cases only imposed certain restrictions or limitations on the manner in which businesses were allowed to operate. We are not aware of any Canadian precedents which have interpreted disease as being physical damage. If that issue was to be litigated in Canada, most likely our courts would turn to the US for guidance. One such example of a case out of the United States is Motorist Mutual Insurance versus Hardinger, where the United States Court of Appeal for the Third Circuit determined that contamination of a well with E. coli may constitute direct physical loss for the purpose of a homeowner's policy if the presence of that disease made the structure unusable. Now, if the property damage argument fails, insureds may argue that their loss or their business interruption was due to the stay-at-home orders of various municipal or provincial governments, and which had the effect of shutting down the economy. Civil authority provisions in CGL policies can be classified into two groups. First, where access to property has been prevented because of damage to neighboring property, and second, where access has been prohibited due to direct damage to the insured's own premises. While many U.S. courts have interpreted these civil authority provisions as requiring a complete denial of access to the premises, the orders made by Canadian civil authorities do not usually go that far. Instead, such orders impose restrictions on how a business can operate. One example is by preventing the number of people who can attend a restaurant. Orders permitting access, but in reduced numbers, will not normally trigger BI coverage. The second issue I want to address is whether certain exclusions in policies may apply. Most CGL policies have an exclusion for property damage losses that are caused by the discharge, dispersal, release, or escape of pollutants. A common definition in CGL policies for pollution includes irritants or contaminants, which may be broad enough to include a virus. The Ontario Court of Appeal in Zurich Insurance versus 686 Ontario interpreted this pollution exclusion as extending to activities that carry a known risk of pollution and environmental harm. In that case, the pollution exclusion did not apply to bodily injuries caused by carbon monoxide. Based on this definition, it would appear unlikely that the pollution exclusion would be applicable to the COVID crisis. Another exclusionary wording is contamination. In that D.P. Murphy case, while the claim was found to be property damage, it was ultimately denied due to the contamination exclusion. The fumes from the gasoline triggered the exclusion because the premises were unusable due to the introduction of unwholesome or undesirable elements. It's possible that courts in Canada may classify COVID-19 in a similar manner. Finally, some policies contain exclusions against viruses, microorganisms, or communicable diseases. We have not seen any case law which interprets these exclusions, but most likely COVID-19 would fall within those categories. Then there are the considerations of timing. Specifically, for what length of time is the business interrupted due to COVID? If the actual presence of COVID within the premises constitutes physical damage, then the period of business interruption could only encompass the time that COVID was physically present in the business. Since COVID can be relatively easily removed through a thorough cleaning, the period of interruption could last for hours or at most a few days. Many policies contain a minimum period of interruption before BI coverage can be triggered, which is usually less than the amount of time it might take to remove all traces of COVID. Mitigation is another issue to consider. For example, can a BI claim be advanced for losses arising from having to sell products cheaply just to get rid of them? Canadian courts have determined that losses should be mitigated, even if it means selling property at a steep discount. In the COVID situation, restaurants have found alternative revenue streams, such as operating curbside pickup, utilizing food delivery services, or selling meal kits to supermarkets. Merchants are conducting sales online or operating their business in compliance with local social distancing orders. Even so, more than 50% of Canadian small businesses reported their sales revenues as being less than half of pre-pandemic levels. The courts will have to determine whether a business is obligated to do whatever they can to earn money, even if it means operating at a loss. Finally, as for the future, while there have not yet been any judgments involving BI coverage and COVID-19 cases in Canada, we know that class actions have already been filed against insurers for not making payouts for business disruptions and closures in Saskatchewan and Quebec. We are also aware of the possibility that legislation could be passed requiring insurers to accept COVID claims for BI. This legislation has already been contemplated in many American states and even in Congress. However, no such legislation has yet been introduced or even discussed out loud in any Canadian legislature. COVID-19 is creating many challenges for the handling of BI claims. For insurers, the first step will always be to carefully read the policy, as each policy will have a different exclusion or different coverage language. While courts have differed in their interpretation of what constitutes physical damage, this is usually seen as a common prerequisite for triggering a BI claim. Even so, there are many exclusions and defenses that may be available to carriers. Canadian courts have yet to weigh in on any of these issues. Thank you for watching my video. If you have any questions, please feel free to send your inquiries by email to info@harmony.org. We will organize the responses after reviewing the questions. Have a great day.